Hello there.
Hi, Scott.
Up in Cambridge, this is Scott Fulton down in Washington, D.C. It's a great pleasure to bring to you an annual event of the Environmental Law Institute. This is our program that looks at the environmental cases that are coming before the Supreme Court this term, starting in October, and several of the leading ones that have come in the past. I'm the president here at the Environmental Law Institute, which is a research and educational institute centered in Washington, D.C. This is just one of many Environmental Law Institute programs that we'll be bringing forward this year. We want to encourage all of you who are attending this program or listening in on this program to be part of the ELI family. For law students, membership is free, so you certainly should do it. There are very few things free in this world at this point, as you know all too well. And if you do belong, then you'll be able to participate in all of these ELI programs without charge. Just note that we also put out a weekly job listing that may be of interest to some of you. Today's program is one that the entire ELI community always looks forward to, our Supreme Court review and preview. As suggested by the title, our panelists will offer some reflections on what's gone before, but also anticipate what lies ahead. The Supreme Court, of course, represents the pinnacle of American jurisprudence. But what happens in our court is also of increasing interest on the international front. And I participated in a conference 2 weeks ago in London, hosted by the Supreme Court of the United Kingdom, entitled Adjudicating the Future, Climate Change and the Rule of Law. This was a fascinating gathering of judges and academics to discuss the role of the courts in the climate change context, both in terms of enforcing nationally determined mitigation commitments that become enshrined in domestic law, but also in ensuring that the various planning decisions that come before the courts take into account climate adaptation and resiliency needs. If you want to know more about that conference, you can find the conference proceedings through the King's College of London's website. But for purposes of today, I just want to say I was struck by the extent to which the decisions of our Supreme Court in the climate change area are the subject of intense study all around the globe, with Massachusetts versus EPA, for example, being held up as an illustration of the difference that the judiciary can make in the climate change context. AEP versus Connecticut, UARG versus EPA, all the subject of great interest and discussion at that conference. And so how wonderful it is that to inform the understanding of all inquiring minds about the decisions of our Supreme Court, we have two true giants in our field bringing their thoughts and perspectives today. For those of you who have gathered at Harvard today, the panelists really don't need introduction, but for the many people across the United States who are joining this gathering via phone or computer, I want to share just a brief word of introduction. First, we have Professor Richard Lazarus, who has himself argued more than a dozen times before the Supreme Court. He's written a book on environmental law that sits on many of our bookshelves called The Making of Environmental Law. I first met Professor Lazarus when we overlapped at the Justice Department in the 1980s. He was at that time the environmental star in the Solicitor General's office and has in the years since established himself as truly one of the leading thinkers and experts on the decisions of the Supreme Court in the environmental space. Our second panelist is Professor Jody Freeman, Professor Freeman is the Archibald Cox Professor of Law and the founding director of Harvard's Environmental Law and Policy program at the law school. She's plainly one of the premier scholars on administrative law and environmental law. Our paths intersected in the 2009-2010 period when she served in the White House as counselor for energy and climate change. I was a general counsel at EPA at the time. And in that role that Professor Freeman had, she was the architect of the president's historic agreement with the auto industry to double fuel efficiency standards and establish the first set of greenhouse gas emissions for the transportation sector. And this was, of course, a key piece in the Obama administration's initial suite of greenhouse gas rules under the Clean Air Act. I'm sure that Professor Freeman has found, as have I, the decisions of the court over the past several years particularly intriguing, since the court's attention has focused on the fruits of our labors during our time in government. So I can think of no scholars better equipped to take us through today's reflection and projection than these two we have here. Professor Lazarus, the floor is yours.
Great. Thanks a lot, Scott. All right, ELI is a great organization. Most of all, happy first Monday in October. So here's what we're going to do. We're going to do a review of last term, October term 2014, then do a preview October term 2015, and Professor Freeman and I will do a tag team. All right, October term 2014, I want to start out here with some basic stats from the term. So how many merits opinions did they have in 2014? They continued their downward trend. For the past several decades, we had 66 cases decided on the merits after full argument. 40% of them were unanimous. If you add the 8 1s and 7 2s to the term, it takes about 60% of the cases. One of the big stories of the term, though, was the divided cases. What happened in divided cases? We had 10 6-3 votes. Now, that's not 6-3. That shows you the more 5 conservative justices up top, the more 4 liberal ones down the bottom. So of those 10 6-3 votes, this is what happened. On 8 of those occasions, 2 of the top 5 went down to join the 4. Only one time did one of the 4 go up to join the 5. So you get a sense of sort of what happened last term. The liberal bloc really held tight. And then there was one sort of mixed case where they kind of mixed and matched 6-3. But look at the 5-4s. There were 19 5-4s decided in 2014 term. Justice Kennedy stayed put for 5 times. But the real question is, how many times did Justice Kennedy drift down? 8 times. So he came down 8 times. Chief Justice Roberts came down once. Justice Thomas came down once. Only on one occasion on those did only one of those drift up. So you really had the 4 holding completely steady as a block. And then you had some odd 5-4 votes. This was twice they had this kind of mix. This is a healthy kind of mix. You'd like to see it. Another kind of mix happened one time. Again, mixing it up one way or another. In the majority, who was the majority in most cases? Who was in the majority, the least number in all cases? Breyer, 92%. Clarence Thomas, 61%. You'll see Breyer really played a major role in decision-making last year. Now look at majority in the divided cases. How did that come out? Breyer, 86%. Thomas was the least at 34% of the divided cases. And what's fascinating about this is it's quite a switch. Look at it. This was last term. This is 2014. Look at it for 2013, what it was. They were the same. If you go back 6 years before that, what was it? Thomas was 85%, and Breyer was 68%. So it's very interesting how Justice Thomas has drifted in terms of divided opinions and all opinions in the court in the past several years. If you look at the majority opinions authored, Now, Kennedy had the fewest opinions, but he had some big opinions last term. What's fascinating, though, is so they're roughly equal when it comes to number of majority opinions, opinions for the court that they wrote. But total opinions authored. Now, if you look at sort of majority, concurring, dissenting opinions, you add all their opinions together, there were 178 opinions authored. Look at this. Clarence Thomas wrote 37, Alito 30, and Scalia wrote 28. They wrote well over half. Those three wrote well over half all the opinions that were written last term, compared to the others on the court. So they're writing a lot. The conservative justices are writing a lot. If you look to total opinion pages, Justice Thomas wrote 432 pages. Ginsburg wrote the fewest, 149 pages. The median was 207. So Clarence Thomas may not speak a lot of argument, but he's speaking a lot when it comes to written opinions. He has a very strong and powerful voice on the court. It's a mistake to underestimate sort of what he's doing as a justice. Michigan.
And now to the blockbuster environmental law case of the last term, Michigan versus EPA. The Supreme Court struck down EPA's mercury and air toxics rule, a much-awaited, long-awaited rule to regulate mercury and other toxic emissions from the nation's power plants, reversing the D.C. Circuit decision. This is what the rule looks like in the Federal Register when it came out in 2012. And this is what the emissions might look like when they come out of power plants. This rule was struck down because EPA failed to consider cost at the threshold moment of deciding whether it was appropriate and necessary, that's the language of the statute, to regulate these sources, these power plant emissions of toxics. The statute instructs EPA to consider whether it is appropriate and necessary to regulate, and the court said at that threshold moment EPA had to consider cost, which it had not done. This rule is promulgated under Section 112 of the law. Those of you who know the Clean Air Act know it's the toxics provision, and it normally requires a step-by-step process. There are over 180 pollutants listed in the Clean Air Act as toxic pollutants. Congress put them there. The job of EPA is to list the categories of sources that emit these pollutants, and then, as a separate step, set emission standards for them, set the limits for those categories of sources. The standards required are pretty tough. They're maximum available control technology standards, and they apply to all major sources. And my only point here is to tell you, what determines whether you're regulated here is whether you emit these pollutants in a significant amount, enough to trigger being covered by standards. There's no cost-benefit analysis that EPA does under the normal 112 process for all sources except for power plants. For power plants, I'm going to skip that. For power plants, they have to take an extra step, and that's because Congress put the extra step into the toxics program. Congress added here under 112N1A that for electric generating units, which I'm going to call power plants for the rest of this talk, the administrator has to first perform a study of the hazards to public health that are expected to occur as a result of emissions after the imposition of requirements of this chapter. What that means is the extra step is to do a health study after the implementation of the acid rain program that was put into the Act in 1990 when these provisions were put into the Act. So the toxics program and the acid rain program comes in together in the amendments of 1990. And Congress says, before you decide whether it's appropriate and necessary to actually also regulate power plant emissions of toxics, go look to do a public health study and see if perhaps the other regulation under other programs of the statute have taken care of this problem. So that's the extra step. They shall perform this study. It's non-discretionary. And then the administrator shall regulate these sources if the administrator finds it is appropriate and necessary to do so after consideration of the study. After consideration of the study, which refers to public health. The EPA went through this process in this instance before listing power plants for regulation and setting standards. They did this. They did the required health study. They affirmed an earlier finding that dates back to 1998, the history of which I will not include. But trust me when I say there has been a long-standing appropriate and necessary finding that it is necessary to regulate these power plants, but it was never actually done until now. And they reaffirmed that appropriate and necessary finding. They said it's appropriate because there's a residual health risk after looking at how all the other programs of the law have done to control the risk of toxic emissions, and because there is technology that can control these toxics. And it's necessary because the other programs don't address it. They make that finding and do not take cost into account. Okay? They do this based on what they view as public health risk, requiring additional regulation of these sources. The regulatory impact analysis was in fact done. In other words, EPA did in fact conduct a cost-benefit analysis to satisfy an executive order that requires that they do so for all major rules. They didn't do so because they believed it was required by this program of the Clean Air Act. They did it because they're required to do so because the White House, through the Office of Management and Budget, requires them to do so. And this is what it showed. Costs, $9.6 billion. Benefits that are direct, $4.6 million. The M is not a typo. And $37 to $90 billion in ancillary, or what we call co-benefits, that come from controlling not necessarily the mercury and other toxics, but other pollutants that they may transform into, like certain particulates, and additional pollutants that are more conventional pollution. So this was the way the cost-benefit analysis broke down, but EPA quantified, be with me now, they quantified only one of the direct benefits from mercury, because it turns out it's really, really hard to quantify all the health benefits from saving people from exposure to toxic air pollutants. Why is that? To make it real simple, we don't generally conduct controlled studies where we expose people to fish tainted with mercury in order to figure out just how bad it is. So it actually turns out in environmental law to be really hard sometimes to quantify benefits because we don't do these kinds of tests for ethical reasons. The DC Circuit struck down the DC Circuit upheld the rule. I'm focused on Judge Kavanaugh, so I'm thinking of striking down. Judge Kavanaugh dissents, and he dissents and writes a very strongly worded and lucid dissent that turns out to read a lot like a cert petition. So he saved challengers a lot of time, and he said, the problem is EPA didn't even consider the cost when deciding whether it's appropriate and necessary to regulate. That's billion with a B, people. And then we get to the Supreme Court. At oral argument, I want to point this out, the Chief Justice had a hard time at oral argument with the idea that the ancillary benefits, which dwarf the direct benefits, right, the co-benefits, are, in his view, are they the basis for this rule? Are they the reason why you can justify this rule on cost grounds? And you can see here he says, this doesn't seem quite proper because it seems like you're bootstrapping hazardous air pollution regulation from the benefits that accrue from other things. And you can see in response, one of the counsel for industry, Paul Smith, who did a terrific job at oral argument explaining how the toxics provision works in the Act, he said, well, actually, Mr. Chief Justice, EPA quantified only one of the benefits. There are an awful lot of other benefits. And then he explained particulate, how toxics get aerosolized and turn into particulates, so that everybody would understand that that small number of direct benefits didn't fully capture what is on the benefit side of the ledger. The court faced the hard legal question for it, which is whether when making an appropriate and necessary finding, costs may not be considered, the agency may consider them, or whether the agency must consider them. So the court is interpreting what the language appropriate and necessary means when you're deciding whether to list a source for regulation. And the answer, the agency must consider cost. That is, appropriate is a capacious enough term to include considerations of cost among other factors. And Justice Scalia writes the opinion for the majority. I learned how to do that because Lazarus is so good with his slides that I just have to do something. And the court, 5-4, holds that on step 2 of Chevron, those of you who know the Chevron doctrine, while the language appropriate and necessary is ambiguous, it was unreasonable to interpret it as excluding cost consideration. The agency must consider cost. Justice Scalia said, appropriate naturally and traditionally includes consideration of the relevant factors. It's a capacious enough term. One would not say it's even rational, never mind appropriate, to impose billions of dollars of economic costs in return for a few dollars of benefits. And Justice Scalia, moreover, said, we will stop there. What the court did not do is they did not require a formal cost-benefit analysis, which would normally lead to a marginal cost analysis about the point at which it's worth regulating. That's not what the court requires here, just cost consideration. And then the court also indicated that it would not go into the matter of whether these collateral or co-benefits, these ancillary benefits, were a legitimate basis, should be included in the cost-benefit analysis justifying the rule. Petitioners urged them to do this, and they refused to take that step, leaving it lie for the moment. The dissent, powerfully argued by one Justice Kagan, writes that the court is, first of all, it's important to note, the dissent agrees that cost is almost always relevant. The dissent embraced the notion that normally cost should be part of regulatory analysis that agencies do. That's 9 justices for this principle now. That's a unanimous court for this principle. So this is a striking feature of the dissent. And then Justice Kagan says the appropriate necessary finding that these sources should be regulated was only the beginning. It was a kickoff moment, and later EPA sets the actual standards to control these sources, and later the agency considers cost in many, many ways, and the court has ignored that later on cost does come into play. And she said the majority thinks it's entirely material and ignores the many ways that cost plays a role in this decision. Here's what the court did not do. Now, this is why many people reading this decision and the media portrayed the case as actually not a bad loss for the environmental side and not a bad loss for the government, because the court didn't do some things. First of all, the opinion was quite restrained on the part of Justice Scalia. You read Scalia opinions recently, and he's pulling his hair out. Well, you know what I mean. Contrast this opinion, the restrained nature of it, with, say, his dissents in Obergefell and in other cases, in the gay marriage case, and in, where else did he have he went a little
King
crazy.
Burwell?
King. This decision compares to, it's almost like a different person. Very restrained, perhaps to keep Justice Kennedy's 5th vote in his camp, but nevertheless, here's what the court did not do. It did not require formal cost-benefit analysis, as I pointed out, to justify the decision to regulate. It did not reject ancillary benefits, as I mentioned, as legally relevant to justifying a rule. They didn't even vacate the rule. They just remanded it back to the DC Circuit, which presumably will remand it to EPA to fix, okay? But here's what the court did do. And I want to suggest to you that perhaps it's a worse loss than it may first appear. First of all, granted cert. It granted cert, which was surprising, entirely unnecessary. The DC Circuit had upheld the rule, and so the court wanted to take this case. They ruled against EPA on Chevron Step 2, where agencies are supposed to get deference most of the time. Never a good sign to lose at Step 2. Quite shoddy treatment, in fact, given to Chevron in this case by the Supreme Court of the United States. The words appropriate and necessary, you do a survey of any administrative law professor you can find and ask them, are the words appropriate and necessary ambiguous enough to defer to the agency's reasonable interpretation? And you would get a yeah. And yet, no deference here. And here's what's important, really important. The court flipped the presumption from a line of cases, which some of you may have read, starting with American Trucking and going through Entergy to Homer, that establishes that ambiguous language in the statute leaves it open to the court, open to the agency to exercise their discretion about whether to consider cost. In fact, in American Trucking, the court had said, and this was an opinion also authored by Justice Scalia, the court had said, Congress needs to provide a textual commitment to require cost for the agency to consider cost, and that is entirely dispensed with in this case. In fact, ambiguity means cost must be considered. This is a significant change, a significant advance from the prior line of cases. And moreover, the court suggested, Scalia's opinion suggests that it is actually now, cost consideration is now required to satisfy arbitrary or capricious review under State Farm. In other words, it's now a staple of administrative law. That is, always cost should be a relevant factor in order to defend the rationality of your decision-making, quite apart from the Clean Air Act. This is a real victory for adherents, advocates of cost-benefit analysis. It pushes the doctrine much further than it has ever gone before. This principle at the bottom of the slide, that ambiguity means cost consideration should always be considered, that it should be considered, part of arbitrary capricious review. This is a significant shift from the doctrine to date. The D.C. Circuit has flirted with this before, but the Supreme Court has never embraced it.
All right, the next two cases we're going to talk about, or I guess I'm going to talk about, are not the big ticket items. Michigan versus EPA, that's the big case of the term. Yates versus United States, the case many of you heard about. This had one of the more unusual questions presented ever before the United States Supreme Court, and that is whether a red grouper is a tangible object within the meaning of 18 U.S.C. 1517 of the Federal Criminal Code. Now, the case comes up in the context of John Yates. John Yates is a captain of a fishing boat. He's stopped out in the water, and they find out, the federal agent finds out that he's got fish which are basically too small for him to be doing. So the federal agent says, I want you to go to the dock. I want you to go to the dock so that basically we can charge you with this offense. Between the time he finds it and he gets to the dock, he tells his crew to throw some of the fish overboard. So the question becomes whether or not he has violated this provision. Basically, knowingly destroyed, mutilated, concealed, covered, falsifies a tangible object with the intent to impede, obstruct, or influence the investigation within this provision. So the question is a fish a tangible object or not? And the answer is, so you may already know, the answer is it's not a tangible object. Opinion is written by Justice Ginsburg. It's a kind of a splintered opinion. The court, a pretty unusual makeup of justices in this case. And basically, what Justice Ginsburg for the court says is, of course a fish is a tangible object, right? That's easy. But in this context, right, context is going to trump text. We actually look at the purpose of this statute. And the purpose of the statute, 18 U.S.C. 1517, it wasn't to basically make it a crime to destroy all physical evidence. It was really designed to deal with a certain kind of evidence, certain kind of documentary evidence, deal with different kinds of transaction fraud, especially in the banking and marketing industry. So it said, I'm not just going to buy it. She relies on two wonderful Latin canons to this. One is you look for the word, basically look at the company that it keeps to decide what it means, and you look when general words follow specific words, or specific words follow general words, then the general words, you narrow their meaning based on the specific words in the provision. Led to a great moment of oral argument when Justice Kagan said she didn't know how to pronounce is Durham generis in front of the court, and she got Justice Scalia to help her out, creating great laughter in the courtroom. And I liked it because I never know how to say them either in the case. Justice Alito wrote a concurring opinion, for some reason denying Justice Ginsburg an opinion for the court. I don't know why he did it, but he didn't join her opinion. He just wrote separately and joined the judgment. And he said he was convinced by three features: the statute lists of nouns, its list of verbs, and its title. So it's the same idea. Context wins here. They didn't really mean to make tangible fish in this particular statute. And this is a statute, by the way, which makes it a felony, subject someone to 20 years in prison for doing this. So it's a pretty big deal. He actually only got 3 months in prison for it and a few years of basically supervised release. But still, it's a felony conviction as a result, although that now is gone. Though the winner is Justice Kagan. Justice Kagan writes the dissent in the case. She's writing for the case books here. She had a lot of fun with this opinion. The answer would be easy, yes. Term tangible object is obvious, it's clear. And she says the ordinary meaning of a tangible object includes fish. And probably for the first time, she managed to cite Dr. Seuss in a Supreme Court opinion, one fish, two fish. She then also goes after Justice Alito by accusing him of an odd game of Mad Libs in the concurrent purposes.
They're too young for Mad Libs.
Yeah, well, she actually, if you're beyond this, she writes a pretty strong opinion, but the court just splits on it on this way with a very odd split. This is really the most important part of the opinion for Justice Kagan, and that is she says, right, I think that it's covered, but this is a really bad law. I understand why the majority is doing what it's doing here, right? This is bad. It gives prosecutors too much leverage. But I just don't have discretion. We don't have discretion as judges to rewrite the law. But what's interesting about this, and it's similar to what Jody was saying a moment ago about Michigan versus EPA, there are 9 justices who actually think that costs generally should be considered. There are also 9 justices who think that the prosecutors are going too far, and they're overreading these statutes. So in this case, you can go that way. In other cases, they may. Kansas versus Nebraska. This is a case involving an allocation of waters between, guess which two states, right? Kansas and Nebraska. It's an original action which has original jurisdiction in the Supreme Court. And in this case, what was involved is there's an interstate compact between Kansas, Nebraska, and Colorado. Interstate compact approved by Congress, which allocates waters in this basin, Republican River Basin, between those two states, because this basin basically is right there at the border of those three states. And the question in this case was whether Nebraska had been cheating, whether Nebraska had been using too much water or not, or using its fair share under the compact. And the Supreme Court held an opinion written by Justice Kagan, and this is what happens, by the way, when you're the junior justice on the Supreme Court. Right? These are the opinions you write. Right? You read Kansas versus Nebraska. This is not like one that you're like desperate to write. So in this case, basically...
It's so mean. That's so mean.
It's true. It's true. What the court did was the court upheld, right, the special master's findings. And the special master found, first of all, that Nebraska had knowingly violated the compact, had recklessly violated the compact. Kagan couldn't help herself. She said their argument response doesn't hold water. I mean, she's just constantly, whatever the opinion is, she's trying to have fun with it. So she says, doesn't hold water. She says they did it recklessly. One state cannot gamble with another state's scarce natural resources. And that's what they had done here. The bigger issue in the case was basically whether they'd done it knowingly or not. They said they'd done it negligently, not knowingly, and what the penalty should be. And the court also upheld the special master's conclusion they should pay both in terms of the water that was lost by it was 70,000 acre feet, which I think I have down is about, I think it's 23 billion gallons of water. So it's a fair amount of water that Nebraska had stolen from Kansas. The big question was what the penalty should be. The basic loss damages was 3.7. Whether they should basically have to do punitive damages or not in the case. And the court said, we agree with the special master, they should be punitive damages. The special master said 1.8 million. Kansas wanted treble. They said, we're not going to treble the damages. We don't actually understand how the special master came up with 1.8 billion, but it's good enough, right? We don't know how they did it, but you got to come up with something. And so the court basically upholds that part of it as well. This was part of the opinion which actually split the justices on the court. And that is, it turned out that a settlement agreement, which the parties had agreed to a few years ago, had sort of an algorithmic error in it in terms of how you calculated who should get which water. And Nebraska was saying, look, there's an error. They said we can't use too much water, but actually it's got it wrong a little bit. And Kansas said, we don't care if the algorithm is wrong. You agreed to that. So the question was whether or not what they had agreed to in settling a prior conflict controlled, even though everyone could admit now they made a mathematical mistake in the formulas they put on it. And the court said, we can rewrite it. The compact governs, the settlement agreement doesn't govern, this is all under equitable jurisdiction, and so away we go. The compact Supreme Law of the land, they couldn't change the agreement if they wanted to, so whatever they agreed to since is of no legal effect.
We're going to talk very briefly about non-environmental cases that might bear on environmental law. But first, I must give a shout out to Ephraim McDowell, who has written a terrific case comment on the Michigan case, which will come out in the Harvard Law Review, and make two more quick points about Michigan, which will actually connect to what I have to say briefly about Burwell. And that is, even though the court did not require cost-benefit analysis in Michigan, by requiring costs to be considered, necessarily agencies will have to put them in some kind of context to make any sense to them, which means they'll have to consider benefits, and it'll lead to a rough weighing, rough balancing of costs and benefits, no matter how you slice it. And the court will be the arbiter of whether that comes out in a wholly disproportionate way. So the court, by requiring cost consideration as a default, elevates itself, puts itself into the role of ultimately deciding when the benefits are too meager and the costs are too high. And this idea of the court treating Chevron somewhat shoddily and reasserting itself as the decider in this way and adding burdens to agencies has some resonance, believe it or not, in King v. Burwell. Because this decision, which of course upheld the Affordable Care Act against the second challenge, The challenge was concerned the language in the statute, exchanges established by the state, that is, health exchanges established by the state, whether that language could be read to also include federally established health exchanges for purposes of making tax subsidies available to people to participate in those exchanges. I'm not going to go through the case because we don't have time and that's not our main focus, but the point is the court did interpret the language established by the state to also mean established by the federal government for purposes of upholding the statute. Otherwise, it would have unraveled. And it was a great example of the Chief Justice rejecting a plain, literal approach to statutory interpretation and making sense of a statute that he said was inartfully drafted in many respects, but the only way to make it coherent is to ensure that everybody can get a subsidy no matter what exchange they're on in order to ensure everybody gets insured so that states won't experience a death spiral in their health insurance regimes. So that's the outcome, but on the way to the outcome, we see the Chief Justice in his opinion, now these are 6 justices join total, so Justice Kagan joins this opinion as well. On the way to upholding the Affordable Care Act, the Chief Justice makes a point to say, when analyzing an agency's interpretation of a statute, we often apply the 2-step framework in Chevron. It comes to us often that we should apply, really retreating somewhat from treating it as the canonical doctrine for reviewing agency decision-making. He then goes on to say, here's the test, we ask whether it's ambiguous. Here's the test, we ask whether the statute's ambiguous. But then he gives a mention to this idea that in extraordinary cases, there may be reason to hesitate before we apply Chevron. All of this quite gratuitous, unnecessary. But what this is about is resurrecting an idea that came long ago in Brown and Williamson, a case about the FDA trying to regulate tobacco, in which the court had said sometimes when there are major questions of major economic and social significance, political and economic significance, it's maybe inappropriate to apply Chevron. And the Chief Justice embraces that and manages to sneak it into King v. Burwell and basically retakes the territory he lost in an earlier case called Arlington, in which Chevron was held to be the doctrine that applied even when agencies are interpreting their own jurisdictional reach. So he manages to send a signal that maybe the court will not be deferential, will not apply Chevron in really important cases. And why does that matter to us? Because the Clean Power Plan, the greenhouse gas standards from EPA that govern power plants may wind up in the Supreme Court, and this is a bit of a poison pill. When you put some of this language together with Michigan, you wind up feeling a little nervous if you're on the environmental side and a little bolstered if you're on the industry petitioner side. So there is a lot going on in the background of these opinions.
Right. 2 more quick non-environmental cases, though, with implications for environmental law. The first is McFadden versus United States. In this case, the defendant was convicted of knowingly distributing a substance that was a chemical analog of a controlled substance. It was not itself a controlled substance. The Controlled Substance Analog Enforcement Act. So, and the question basically in the case was, what does the defendant have to know to be convicted of knowingly distributing a chemical analog? The Fourth Circuit had said all they have to know is that they are distributing a chemical substance that humans are going to consume. They don't know anything more than that. The Supreme Court took the case. The Supreme Court reversed. There's a chemical analog at issue in the case for you with chemistry backgrounds. And the court said, here's the knowledge requirement. Here's what you have to know. You have to either know, right, that you had a substance that was listed. You knew it was a controlled substance. If you knew it was a controlled substance, you don't have to know what it was. Or you have to know what it was. You have to know exactly what the analog was, but then you don't have to know that it's a controlled substance. So you have to know one of those 2 things. Now, why is this case at all significant for environmental law? For this reason. All the environmental statutes have knowing requirements in them. All the environmental statutes basically have knowledge requirements, and the facts that make something unlawful in environmental law are unbelievably complicated. Whether something is a navigable water or not, whether something is a wetland or not, whether something is a waste or not, whether something is hazardous or not, whether you violated a permit means exactly how much you're putting out. To actually show the defendants know all those kinds of facts would be really hard. And historically, the government has won all of its cases without having to show that kind of mens rea. They've won on basically reduced mens rea. And there's a lot of tension out there between the theories the government has won on in environmental cases with very reduced mens rea and actually what the courts are saying in other kinds of criminal contexts. And this is headed at some point to the Supreme Court. There's some circuit conflicts brewing out there on this issue, and when it hits the court, environmental criminal prosecutions could find themselves in a little bit of trouble. Horne versus Department of Agriculture, this is a takings case in a very unusual context. It involves raisins. There's an old law from the sort of early New Deal era which regulate growers of raisins, and it tells growers of raisins that you have to give us a certain percentage. The government, a raise committee from the government says, here's the percentage of your crop you have to turn over to us. Because we want to stabilize the price. We want to make sure there's not too many raisins out on the market. So it was 43% recently. 43% of the crop the growers had to give to the government. The government said, we're going to donate these things or give to school programs, the rest. If any proceeds come back, we'll give you some money back. And the question was whether or not that was a taking or not. And the Supreme Court said, right, it's a taking. They said, this isn't a regulatory taking. This is a physical appropriation of the property. It doesn't matter that you didn't take all their raisins. That doesn't make any difference. It doesn't matter that it's not real property, but it's personal property. It doesn't matter that you give them a little bit of money back later. That would be whether you get just compensation or not. This is a per se physical taking in the case. It was pretty easy for the justices on that one. There's some great lines in the opinion by the Chief Justice Roberts. He says this notion of you're doing them a favor by letting them sell their raisins and let them sell wine, let them eat cake. No, it's not such a big deal that you're giving them permission to sell their raisins in interstate commerce. And he rejects his analogies that raisins are like a hazardous waste, a dangerous pesticide. Because the government relied on a case when you had to get a permit. So they're not.
They're a healthy snack.
They're a healthy snack. At oral argument, Justice Scalia did the same thing. I mean, dangerous raisins. The court also rejected that you could draw an analogy between raisins and oysters, because the government does have heightened protection to regulate oysters at interstate commerce. They said raisins are like oysters. They're private property. They're not public things subject to absolute control of the state. This led to a great moment at oral argument with Mike McConnell, referred to raisins are not wild animals, even if they're dancing, which would take you back to some raisin commercials a few years ago. One of the bigger questions in the case was the government said, well, but even if we're taking some of the raisins, we're actually stabilizing the price, so they're making more money on the raisins that they have they otherwise make. So that's not a taking. The government said, no, that doesn't work. You can't take someone's property and then say, because we're creating value, we don't have to pay you at all for what we've taken. You still have to take it. And they didn't address all the issues. We'll get that to another day. This led to a great final closing moment at oral argument, which I'm not quite sure why it came up. The Chief Justice closed the argument by asking, Mike McConnell used to be a quite distinguished federal court of appeals judge arguing the case. What about the drought in California? How is it affecting raisin? And somehow McConnell ended the argument talking about he didn't know he could take a shower when he got back to California. 2014 becomes, here you go, 2015.
Lazarus. Now, I know some of you may have to duck out to head to class, but I urge you not to. And the reason is...
we have signed notes in the back, no problem.
The reason is you will never enjoy a FERC case more than I hope you will enjoy this presentation of a FERC case.
Carefully worded.
This case is about the Federal Energy Regulatory Commission's jurisdiction, whether it has the authority under the Federal Power Act to boil it down, to promote energy conservation, to control the demand for energy by creating a price for it in wholesale energy markets, whether it has the authority under the Federal Power Act to do that. And I'm going to walk you through why it matters and walk you through the hard legal questions. The reason this is of relevance to you, if you're sort of a pure environmental law person, there's really no pure environmental law person anymore anyway, because the world is all about the integration of energy and environmental law, so you got to pay attention to these cases. But at bottom, there's some potential here, if FERC's order is upheld, if its jurisdiction is upheld, to actually advance some environmental goals if it turns out that doing so here promotes energy conservation and energy efficiency. And also, we will see in the court's handling of this case, again, how is it feeling about deference at the moment, and how does it treat an agency that is adapting an old statute? The statute, the Federal Power Act, is 80 years old. How does the court handle an agency's effort to wrestle with language that really doesn't match very well the modern day, the modern grid, the modern energy system? That's the caption for the case. This is the order, Order 745. And what the order does is I'll say what the order does first. Order 745 asserts that FERC has the authority to tell the operators of energy markets where energy is bought and sold at the wholesale level, interstate energy, to tell them the price they should pay for non-consumption of energy that gets bid into the market. Okay, so consumers can be aggregated and bid in a commitment not to consume at peak times. And the question is, what should that be paid? And FERC has said what the price should be, and I'll explain why. And so the questions presented here are whether FERC may regulate the payments that are made for this non-consumption to people who promise in industries that promise not to consume energy. And second, whether the rate they set was arbitrary or capricious. The Federal Power Act works like this really quickly. This will save you, I don't know, a semester maybe. Section 201 of the statute gives FERC jurisdiction over the sale of electric energy at wholesale and interstate commerce. That's the wholesale market in which energy is traded. But not over any other sale of electric energy, which is interpreted to be retail sales. So sales that come to you. When you purchase energy at the retail level, FERC does not have jurisdiction over it. But Section 206 of the statute also says this: FERC can regulate any practice affecting wholesale rates to ensure it's just and reasonable. Can affect any practice affecting wholesale rates to ensure it's just and reasonable. So these are really the two provisions at issue in the case. The question becomes, does the practice affecting wholesale rates allow the agency to reach out and regulate the price paid for demand response? Bear with me here while I walk through how the markets work very simply and briefly. Wholesale energy markets are competitive. Energy is bought and sold in these markets in real time, and the price fluctuates. And the operators of the markets have to match demand with supply in real time. All bidders get the clearing price. Again, bear with me. When you bid your energy in, whether you have some natural gas to sell, some natural gas-fired power, some coal-fired power, some nuclear energy, you want to sell it into the market, you can power up your plant and provide that energy, you get paid the last price paid for all the energy consumed at that moment. So the most expensive energy bid into the market sets the clearing price for everybody. And they get, that's called locational marginal pricing. LMP, that's all you got to remember. Go to a cocktail party, throw LMP around. You will impress everyone. And FERC oversees the operation of these trading markets, of these competitive markets that are run by regional transmission organizations. Okay? Retail energy markets are different. When you purchase energy and you get your bill every month, that's different. You're not trading in the wholesale market. States set the retail rate you pay for energy. It's based on the cost for utilities to supply you with that energy, and it's a complicated formula, but it is the regulator who sets the rate, and you pay a consistent average rate. You don't look at how the market of energy is changing over the course of the day and go, I'm not going to turn my washing machine on, it's too expensive right now. There's no dynamic pricing, you just pay the rate in your bill. The difference matters because retail rates belong, if you will, to the states. Wholesale rates belong, if you will, to FERC, to oversimplify. And finally, by way of background, what is demand response? This is what FERC is trying to promote. This is what FERC is regulating in the wholesale market, and it works like this. Basically, you're trying to lower demand for electricity, lower demand for energy, instead of paying for more supply. Customers commit to reduce demand, and someone aggregates those customers' commitments and bids it in as if it were supply. But in fact, it's a curtailment. It's non-consumption. And this helps moderate energy prices that can spike, right? So to pay for, at peak hot, super hot days, if energy prices spike to meet that demand, it's super helpful. If you can aggregate a bunch of consumers who promise to turn off their electricity, you don't need to buy the last increment of super expensive energy. So you can imagine the value of bidding demand response into the system. And finally, it assists with system reliability. It allows grid managers to manage congestion and other problems on the system. Order 745 is FERC's rule. Rules from FERC are called orders. Don't ask me. Don't get confused. It's a regulation. And it basically requires that demand response is paid LMP. Again, if this comes out of your mouth at a cocktail party, you will be super impressive. Demand response gets paid, that clearing price, the same price that you would have to pay for supply to turn on other energy. That's the same price that you would have to pay for the energy it supplants, but only when two conditions are met. It has to help the system operator balance the system, and it has to be cost-effective, meaning to have that demand response bid into the system has to lower prices for consumers. In other words, it's cheaper than paying for more energy. It's cheaper to control the demand. Okay, now you know the basics. Now you can understand the legal issue in the case. The D.C. Circuit, in an opinion written by Judge Janice Rogers Brown, struck down FERC's assertion of authority to actually issue Order 745. And remember the slide in which I showed you that FERC has the power under Section 201 to regulate wholesale sales in the interstate markets, but not other sales? Well, the opinion from the D.C. Circuit says that means the retail market belongs exclusively to the states. FERC can't mess around in the retail markets, can't go and try to suck up consumer commitments not to use energy using retail consumers' commitments. In other words, FERC has reached beyond its authority and has gone into the territory that belongs to the states. Demand response, simply put, is part of the retail market. Think about it this way. The people committing not to consume are connected to the grid and operating in the retail market. The energy you would have consumed would have been energy you would have paid for, paying retail rates. So the argument is that FERC has reached beyond its jurisdiction. And finally, the price it used was arbitrary and capricious. Locational marginal pricing overcompensates people. Think about it this way. Why should we pay you what we pay an energy supplier to produce their energy and put it in the system? You're already saving money by not consuming it. So if we pay you on top of what you save by not consuming it, we're overcompensating you. So an economist would say overcompensation, and she says FERC didn't respond to that argument sufficiently. It's arbitrary. And now, what we will see in the Supreme Court, this will be argued this month, shortly. Right? Next week. The term just started today, conveniently, as you know, and so we will see this right out of the gate. Here are the arguments the government's making. Solicitor General Don Verrilli, in his briefs, has basically said, plain meaning. Now, bear with me when I walk through this, because what you'll see is a contrast between what the government's arguing for FERC and what the industry challengers are arguing about what FERC has done here. Look, this is plain meaning. The statute gives FERC the authority over anything that affects wholesale rates. Payments for demand response affect wholesale rates. What you pay for the commitment not to consume is going to maybe bring the price of wholesale energy down or make it go higher. It obviously affects wholesale rates. Therefore, we have affecting jurisdiction. FERC has to ensure, under the Federal Power Act, one of its duties is to ensure payments are just and reasonable. So if payments for DR that are being paid around the country aren't just and reasonable, FERC actually has an obligation, no choice, but to fix it. And the impact on wholesale rates of this demand response is direct and substantial. One of the things the D.C. Circuit worried about was there's no limiting principle for FERC's assertion of authority. They can say anything affects wholesale rates. Anything in the retail market can presumably, maybe marginally affect wholesale rates, and so there's no way to limit. FERC will swallow state authority entirely. The limiting principle problem bothered the D.C. Circuit, and what the Solicitor General in the brief for the government said is impact on wholesale rates here is direct and substantial. They won't be reaching further into the retail market. He also said the price was not arbitrary. They say, FERC says, look, the value of this commitment not to consume is just as important to us, just as valuable to us as more energy. They should be paid the same. And then we get to the other side. Paul Clement, for the respondents, EPSA, these are the basically the generators who are going to lose money if demand response is bid into the system, says this. This case is a naked effort by FERC to reach around the limits on its jurisdiction and get into the retail markets that state control. The framing of this brief says this is all about federalism. It's all about protecting states' rights. This is not complicated. There's a line between where FERC can play, and that's wholesale markets, and where states have exclusive authority, and that's retail markets, and FERC is being sneaky. There's subterfuge going on. FERC can't do indirectly what it can't do directly, and it can't regulate retail rates one way or the other. And if it sets the prices for demand response, it is indirectly, effectively going to set those rates. And finally, FERC is luring you people, luring you and big industry consumers of energy into the wholesale market, promising you money to commit not to consume energy, and then says, Well, now that they're here, we have a real problem of the rates being very disparate, so we got to fix it by imposing one price. That's sneaky. You create the problem and then say, oh, we have to come fix it. Meanwhile, you grab the power that belongs to the states. LMP, by the way, is arbitrary. It overcompensates providers. Like I said, you get double compensation, and I don't care about the rest of his reasons. There's a really interesting, I do, but not for our purposes. Really interesting brief from law professors here. I just want to make one mention. Really high quality, short, brief, effective, that says that limiting principle problem, you thought FERC, there was no way to articulate a principle that would limit FERC to just demand response. Well, there is a principle, and it comes from the case law. And that is that when FERC regulates matters that may touch retail rates, the practices that affect wholesale rates have to be directly and significantly and integrally related to the wholesale market. Just bear with me here. Demand response is directly connected to the price of wholesale energy and can be integrated into the market. It's not like reaching further and regulating labor markets or, as the court is worried about, hot dogs, broccoli, etc. So there's a limiting principle available, and it comes from the case law, long established. And here's the lineup. Clement says, this is easy. It violates federalism. FERC has limited power under the Federal Power Act, not plenary power. States control all of retail, not some of retail. And FERC is doing an end run. And the Solicitor General says, hang on a minute. It's not so simple. FERC's affecting jurisdiction to regulate anything that affects wholesale markets can touch retail markets. It can change incentives in retail markets. But that isn't the same as setting the retail rates that you all pay for energy. It's an incidental impact that flows from its remedial power to make sure anything that affects its domain is just and reasonable. And there's a problem here that only FERC can fix. In other words, disparate prices for demand response. You need a national player to fix this. And if FERC doesn't do it, the states can't fix it because the states definitely are preempted from regulating wholesale rates. So you'd have a gap, and only FERC can fill it. This is easy. No, it's not. This is federalism end run. No, this is a legitimate exercise of federal power to solve a real problem. This is how the briefs are shaping up. Deferred expert agency is an afterthought. And who are they appealing to? All this federalism framing, all this language. You know, there's a lot of money. This is a money case and a states' rights case. And it's actually a money case masquerading as a states' rights case. And it's all being framed this way to get this man's vote. Implications. Implications. I'll be very quick. 1 minute. This case, for those watching energy law and those who care about FERC, could really cut back on FERC's potential jurisdiction. It could wind up saying that states have this exclusive area of retail that FERC has to stay out of. That would be a new principle, and that could severely cut back on FERC's power. For those of us who are interested in the intersection of energy and environmental law, we're concerned because this could put real obstacles in the way of promoting things like demand response. And also promoting things like distributed energy generation, like solar on your rooftops, that someone else might try to aggregate and bid into the system as a source of supply. But if FERC can't regulate the price for that, if that's not considered affecting wholesale rates, if that belongs exclusively in the retail domain, then all of those potential sources of alternative energy won't find a champion at the federal level and will depend on the states, and the states are quite different about how they promote or don't promote this. There are an awful lot of incumbent generators of electricity in the states who prefer it just as it is. More demand for their product is more money for them, and the more we aggregate alternative energy and the more we bid in demand response, the less money they make. That's why it's a money case. So big implications, not just for the energy sector, but for the environmental sector. And the very final implication is just, again, will this agency get deference as it struggles with a law that was designed in the 1930s and amended a couple of times, but had there was no ability to see at the time that we would have regional grids, even international grids, that we'd have competitive wholesale energy markets. The markets, the economics, the technology, everything has changed dramatically. How do you solve this problem with an old and aging statute? And if the court doesn't defer, you might think about that as a sign about how it might treat EPA doing the same thing with the Clean Air Act.
The last case I'm going to mention, just very quickly, a case the court granted just this past Wednesday. It shows you the full range of cases the United States Supreme Court has on it. They granted a case called Sturgeon v. Masika, which surprised everyone over the federal government's opposition. This is the question of the case. whether Section 103C of the Alaska National Lands Conservation Act prohibits national park, da-da-da-da-da. Here's what the case is about. It's whether or not the National Park Service can stop Mr. Surgeon from doing hovercraft moose hunting in national parks in Alaska. It was no one really thought the court was going to take this case. That's what the case is about, whether he can do it or not. When the court takes a case like that, that's not good news for the government, because there's really no reason to take this case. It's not an obvious, hugely important legal question. So they grant it. They're probably thinking reversing. So that means the government's going to have to do some catch-up here to convince the court that what the court thinks travesty has not happened. Here's the language at issue. It says, no lands which before, on, or after December 2nd are conveyed to the state, any corporate, any private party, shall be subject to regulations applicable solely to public lands for its units. So they say, look, we're putting our hovercrafts on state waters in national parks. Those are owned by the states. Those are now waters owned by the states. They own the submerged lands. And that means you can't apply regulations to us, because that is state-owned property. What we're on, the hovercrafts are on state-owned property. That's the argument. The government's got a pretty good argument back, which is why they won. And the courts below, they said, no, you got to read it more carefully. You're reading it too quickly. Read it a little more slowly. It says the only regulations that you're exempt from are regulations applicable solely to public lands for such units. So it's just the Park Service regulations which apply just to parks in Alaska. The regulations in question, which ban hovercraft hunting, actually apply to all national parks in the United States, not just those in Alaska. That's the district court ruled. That's the Court of Appeals ruled. Regardless, you would not think this was a cert issue, right? The court grants how many cases a year? 66 cases out of about 10,000 requests. This is one of the top 66 legal issues in front of the United States Supreme Court. Seems hard to believe, but the court's docket often has a lot of those kinds of incongruities. Government here is going to, I think, they have a good chance they can win, but they probably are just scratching their heads right now. They never thought in a million years the Supreme Court would grant cert in this case. And that's it for the preview, and we're happy to take some questions.
Yes.
So I think a lot of the hullabaloo, first of all, thank you very much.
You have to repeat the question.
All the hullabaloo in the last, at the end of the last.
One sec. What we'll do is, folks, absolutely feel free. People got to go, but if few people just want to hang out for a few minutes for questions, that's also totally fine. And I'll just repeat the question because it's fun.
Thank you all for staying. You had classes at 1.
Thank you very much.
Don't tell your teachers we said it was okay. We never did that.
Yes.
Sort of wrap up at the end of the last time.
Well, thank you so much, Professors Lazarus and Freeman. Really outstanding, stimulating, scintillating, a lot to look forward to and watch. I think actually, aren't we?
Yes, but we'll take them from our students. So we'll bid you farewell, Scott, and we'll still take a few.
Right, if you want to listen to the students asking questions, that's also great. It's up to you. We got some students here.
Sure. Well, I'll stay on.
Okay. All right. Ms. Solomon Strauss.
Thank you. So I guess the popular media, I think, opinion at the end of the last court was, wow, look how surprisingly liberal this court was, and all these great liberal things. And I feel like a lot of the pushback was, well, hang on, because these are some really conservative questions, and you're moving the bar into the liberal answer to the conservative question. It's sort of a misnomer to call the court liberal. And all of that's wrapped up in Chief Justice John Roberts' opinion of himself and the way the court should be moving. So I guess my question is, how do you think that those perceptions of the court's perception of itself and the types of cases it's taking are going to affect the way the environmental and particular questions come out? As I feel like you could really frame those as either conservative or liberal, and how does the court's perception of itself push the way the court is going to decide these?
Yeah, I think that's a very fair characterization of the court. I mean, basically, what you had happen the last term, it looks liberal, more liberal.
You got to repeat the question.
Oh.
Yeah.
Well, the basic question had to do with whether, this is for the other audience. I think the other audience is probably gone now, so we'll stick with the audience here. And that is, the court looks more liberal because they rejected more conservative positions, that the court may have overreached a little bit on the cases they granted, thinking that they would reach some more conservative results. The fact that they rejected those more conservative results doesn't mean the court is liberal. It just means it's not quite as conservative as people thought it was. I think that's a fair characterization of what happened. It doesn't make it sort of less significant. It just means that it's not fair to say like it's a liberal court. It's not as conservative a court as people thought. But embedded in that, this is what I think is really interesting, is to see what happened last term. And that is, it almost seems like a real strategy of the four. It's a minority strategy, right? There are 4 more liberal, there are 5 more conservative. And I think the former liberal justice said the only way that we're going to win anything here is if we go lockstep. If we link arms and we're not going to fight, even when we disagree a little bit. So they were sort of, in some ways, more disciplined. In other ways, one could say maybe less principled. The conservative justices were saying, we're going to splinter. We're not always going to agree with each other. And so they actually disagreed all the time. They went different ways. Well, the liberal justices were like, don't do it. We will sign on to anything if it leads to a rejection of those arguments. So you see them signing on to reasoning they probably didn't like in King v. Burwell. You see them sign on to different things because they're just not, they want to keep, they care more about the result than the reasoning in that way. That to me is fascinating, sort of the actual discipline on the liberal part. And at one point, Scalia actually, I think it's in one of the gay marriage cases, he drops a footnote. He says, I can't believe the stuff they're signing on to. I said, I'd put a bag over my head before I signed on to some of those arguments. I think that he was just getting frustrated with the fact that the 4 liberals would sign on to anything as long as it led to a non-conservative result, while the conservative justices were actually splintering all over, which is why you see the 6-3s going this way, the 5-4s going this way, and the 4 are just sitting there like this. And part of me speculates that this is, a former dean in action, right? Someone who knows how to act politically and corral the troops is sort of got them acting very strategically.
Maybe one more, because I have to go teach a class in 2 minutes.
Oh, yeah.
So one thing that's always bugged me about FERC's arguments in the Order 745 cases, you have demand response providers literally participating directly in interstate wholesale markets. It's not like, we're talking about retail rates, which incidentally affect, people's participation. And it's purely voluntary. Demand response providers don't have to participate in those markets. Demand can
in fact,
can go
states
ahead.
can ban their customers from participating.
So why isn't FERC argued a more narrow case, which is that these are directly voluntarily participating in wholesale markets and their jurisdiction derives from that, rather than this adjacency argument, which I can see the fear that will lead to, everything's adjacent to the wholesale
Well, I think
market.
the problem is that the response is the same regardless. That is the voluntary nature. And in fact, some of the amici do take more of the approach you're taking and point out that voluntary private decisions to participate in wholesale markets aren't things that the FERC can necessarily control. But what it can do is decide that then affects wholesale rates, and that's the tie. So when these behaviors, that's your argument, right? These behaviors trigger an effect on wholesale rates. But I think the response is still the same. I think Paul Clement's response will still be the same, which is it doesn't matter whether they're voluntarily participating. The effect of regulating the rate paid in the wholesale market is to change the rate paid in the retail market and to interfere with the state's ability to set the rates themselves unilaterally. Now, that may be a specious argument because there are lots of ways in which what FERC does affects how retail rates get set, and that's what the fight is going to be about. The problem is, what I just want to tell you is the level of detail at which the court may actually understand the operation of energy markets and the interaction of wholesale and retail. I mean, you just had to be dragged through it in about 15 minutes, and it's very painful in a way. It's true of many highly technical cases. And the kind of sophistication required to understand the economics of this and how it's really difficult. So what you hope is the clerks are really, really sharp, and some of them have taken energy law, and that they can help bring the justices up to speed. I'm not trying to denigrate the justices, very smart people, but this is a highly specialized area of law, and it's frustrating to see sometimes in the opinions how little basic stuff gets across to the justices, and advocacy is really important in this regard.
And that's why the advocacy perspective is interesting in this case. There are actually three incredibly top Supreme Court advocates in this case. Don Verrilli, the SG, Carter Phillips from Sidley and Austin, and Paul Clement. None of them knows anything about energy law. None of them knows anything about FERC regulation, but they're top advocates. And they know how to master something in order to speak to other generalists. Because they know the decision makers here are generalists. So it doesn't often pay to have an expert advocate who can't speak to a generalist. They're expert Supreme Court advocates. It's going to be a fascinating case to watch. I want to thank everyone very much. Scott, I want to thank you too very much. Thanks a lot, Scott.